Okay, good morning. Today is June 15th, it's 9 a.m., and this is the first meeting, at least in my recollection, of the Nuisance Abatement Committee of the City of Auburn. We're going to take the opportunity today not to hear any particular cases, but to go over the administrative procedures and the purpose of this committee. I want to remind the folks that are in the audience here today that we aren't going to have an opportunity due to our limited time frame to hear your complaints. Hopefully you learn a little bit about our process while you're here today. And as I mentioned to most of you that were sitting there, when we adjourn this meeting at approximately 10 a.m. due to another meeting being held in this chambers, the chiefs and I are available and we can have some brief interaction with you in the hallway to give you further guidance or listen to your concerns. And again, I imagine we're probably familiar with most of the locations we're talking about here, but at any rate, we'll give you that opportunity after the meeting. So the makeup of the Nuisance Abatement Committee is whoever is sitting in the city manager's seat, and both our police chief and fire chief. That is set out in the rules of the Nuisance Abatement Committee. Being our first meeting, we don't have any minutes to approve or particular issues to discuss, but what we do have is a little bit of a change. We had contemplated doing these meetings on a regular basis on the third Tuesdays. Chiefs, if you are okay with it because of the other standing meeting that happens on Tuesday mornings, if we could shift that. And I'll ask Assistant Corp Counsel also Wednesday mornings, third Wednesday at 9 a.m.
That should work.
Does that work? So that we can communicate that?
That's agreeable.
Okay. We'll make that change for the future. We'll advertise that appropriately. So, straight away, we'd like to get into, for the public's knowledge and for staff's knowledge, exactly where this committee gets its authority, the types of issues that we will be hearing, and the types of actions we could potentially take. Again, this is typically for significant issues. It's not going to be a board or committee that hears relatively minor neighbor complaints just related to the inability to get along with a neighbor. These are going to be more serious issues. But with that said, we'll get the official rundown on the authority of this committee from Mr. Garland, our Assistant Corporation Counsel, who's been working on this.
Thank you, Mr. Manager. And it looks like I'm going to need some technical assistance at 30 seconds into this. Let's see. Yeah, well, just how do I get the slideshow? It's a power. You know, I can just scroll through here. Yeah. There's a future for this young man in IT, I think, as for his retirement. Thank you, Chief. You got it. So, thank you, Mr. Manager. Just make sure that we're good. All right. So, as the manager said, this is brand new to all of us, but it's been in the City of Auburn Municipal Code for going on 20 years now, I believe. So, it is a a piece of the code that has not been fully utilized, in my opinion, and I think in the opinion of a lot of people in City Hall and in the two departments that make up the board along with the city manager. So it's out there, it's a tool, and the way I look at it is it's another tool to fight blight and behavior that we don't want in our neighborhoods. So the best way to start, I think, discussing what this is to talk about what it's not. The Uniform Code, the Building and Fire Code, does allow code enforcement officers to declare structures a nuisance based on certain structural issues. As you can see here, this particular house had some slight foundational issues, and based on that, the Code Enforcement Office declared it a nuisance. That's a term of art within the building code, and that's not exactly what we're trying to do here. It's also not an attractive nuisance, so this is relatively unattractive nuisance, but the concept of attractive nuisance is there is something on your property that is so alluring to a certain group of people, namely children and for the most part, that you must, as a property owner, take measures to stop that group of people from coming onto your property and putting themselves in danger. So it's not exactly that either. And it's not the two arms of the criminal justice system, the people and the police working to prosecute crimes. Although there is a certain and significant interaction with the police department, it is not a criminal action or criminal proceeding. So it's the nuisance board. The concept of nuisance comes over from the law of torts. Essentially, you have a duty that's incumbent upon you, along with all your property rights, to use your property in a way that doesn't harm others. So the elements for nuisance in the law of torts: unreasonableness on the part of the defendant, continuance of acts constituting the nuisance. So it has to be, out there. It has to continue for a good period of time. There has to be a causal connection between what the defendant is doing and the nuisance complained of, and there has to be an injury. Now, this exists in the law of torts, as I said, but it's between two individuals. It's between a defendant and a plaintiff. When Stacy and I were in law school, it's basically one of the first things that they teach you is the law of nuisance, because it's fairly straightforward. Is that you can harm other people by using your property in a way that is not illegal, and so that highlights the extra duty that comes with property ownership. But again, it's between two individuals. Now, public nuisance is that concept, but ported onto what in the public sphere. So this is a rather long and legalese description, but I found it helpful. A public nuisance is that which obstructs the public in the exercise of rights common to all. A public nuisance abatable by the sovereign, so fixable by the government, need not involve injury to the plaintiff's right in land. Rather, it is created where the public rights or privileges common to every person in the community are interrupted or interfered with. And it may offend the public morals, interfere with the use of a public place, or endanger property, health, safety, or comfort. And my guess is many people in the audience here, and I know the staff members and committee members are familiar with that last little bit, that there are existences of that in the city that we know of. And I think in a future committee meeting, we'll update the committee on our efforts in litigating against one particular public nuisance that fits that description. But this public nuisance, as described here, is what we're trying to take on and stop within the city of Auburn. Our municipal code has a section on public nuisance. Any building, structure, lot, site, or separately identifiable portion thereof where activities which create an unreasonable interference with a person's lawful use and enjoyment of their own property due to excessive noise and general disturbance of the peace. So that's, as you can see, there's a strong relationship to the more legalistic description and what we have here within our own code. Now, the nuisance chapter has it has 3 sections about defining nuisances. The first 2 largely discuss criminal convictions for certain sections of the New York State penal law. Drug offenses, gun offenses, there's some public health law offenses, but those are specific criminal offenses which, per our nuisance statute, require a conviction in a court of law to render themselves actionable by this body. And that, as the chief can tell you, that's a pretty high bar, and it takes a long time. A criminal case, I don't know how things are these days, but when I was at the district attorney's office, even though the criminal procedure law requires that cases be prosecuted within a certain amount of time, basically every case that I ever had went past that 6-month or 1-year threshold, and that's the timeline that we're talking about for the criminal justice system. So, since that isn't particularly responsive to neighborhood issues that we're dealing with here, there is a 3rd section within the nuisance chapter which also defines nuisances but in ways that are not as reliant or dependent on a criminal conviction. So you can see here, suffering or permitting the premises to become disorderly, operating a business at the premises in a manner which causes it to be a source of disruption for the neighborhood. Activities, I've bolded this, activities which result in numerous police investigations within a 6-month period of time. I bolded this element out because it is the theory of the case in the particular matter that we have in Supreme Court now. That, and if you think about it for a second, that is a real harm that is visited upon neighbors, that within a 6-month period of time, a relatively short period of time, a house in your neighborhood has numerous police investigations. That's something that neighbors observe, and that affects neighbors in a deleterious way. Finally, the last section, I'm not sure how many cases will come in front of this committee pertaining to infestations, but our code does allow for that, and perhaps this section could be used because it's permitting situations or conditions which allow infestation, essentially. This may be applicable to a hoarding situation, although I think we would have to have a fairly straightforward case for that to be something that this board may want to take on. So there are a couple of evidentiary presumptions which I think it's important to touch on. These are prima facie evidence, or discuss prima facie evidence, which means that if certain conditions exist, a rebuttable presumption that the case has been made comes into being. So any building within 1 year prior to the commencement of the action under this chapter where there have occurred 4 or more violations, now violation is a term of art in the nuisance chapter, shall be prima facie evidence that a public nuisance exists at this said location. So if there have been 4 more violations within a year, the plaintiff has, in this case would be the city of Auburn, has made their case, and the defendant may rebut that to weaken the city's case. But that's what prima facie evidence means largely. The second piece of it is any building within the period of 1 year prior to the commencement of the action, there has been presented a preponderance of the evidence of repeated criminal activity which has an adverse impact, and then that's also a term of art, shall be prima facie evidence that a public nuisance exists at said location. So violation, per our nuisance statute, is not a criminal conviction. only a preponderance of the evidence that prohibited conduct is occurring or has occurred. Now, that preponderance of evidence can come in the form of police reports, investigative reports, search warrants, police surveillance, and convictions. Now, those are all things that would come from the police department if available. Some of these things are not going to be available at all times, would be my guess. But there are also things that would constitute a violation, evidence of a violation that can come from neighbors, like the increased volume of traffic associated with the property, or finding controlled substances on or near the property. Bags used to package drugs would be, initially the first thing that comes to mind that I think would fit that description. Adverse impact is, again, a term of art which, if proven, constitutes prima facie evidence of a nuisance. And again, similar sorts of documents can prove an adverse impact: search warrants, undercover purchases, or investigative purchases of controlled substance, arrests for controlled substances, or criminal possession of weapons. Again, these are all things that would come from the police department. But in my opinion, loitering for the purpose of engaging in legal activity and increased volume of traffic associated with the property, complaints to law enforcement, these are all things which can come from neighbors. And we have a complaint form that we'll talk about later in the meeting that I think will be a good way to streamline that. So, the Nuisance Abatement Committee. This is the first or second section of our nuisance code. So it was thought of very highly in the drafting of the code. It imposes appropriate sanctions and proportional penalties as may serve to eliminate public nuisances, and can be exercised either in conjunction with or apart from powers contained in other laws. So, in my mind, this means the police department and policing and enforcing the penal law, without prejudice or use of procedures and remedies available under such laws. And that it's thought of as an additional and appropriate method of law enforcement in response to the proliferation of public nuisances within the city of Auburn. So moving on to the administrative process, notice and opportunity to be heard. That's the code speaks of that, and this is a due process right. The city must serve notice upon the owner, lessor, lessee, and mortgagee by code. And I think it's worthwhile at this point to kind of take a step back and just to delineate where we would be in the process. The best way for me to describe that, I think, is the analog in litigation would be this is the time for summons and complaint. That the city would have basically built a case, and in our opinion, the Corporation Counsel's office, that case would be strong enough that it would survive an Article 78 proceeding in Supreme Court if the defendant chose to challenge. So we want everything buttoned up at this point. We want to give the property owner a lot of material and a lot of things to think about prior to the notice and opportunity to be heard. Basically a punch list of things that need to happen within a period of time. That this committee can make rules, and we'll get to that in a little bit, but I think at the very least a month's time prior to the service of notice and opportunity to be heard, we would then have the hearing after basically the papers have been delivered, served on these individuals here. So the hearing, the city nuisance chapter is silent on the details and the particulars of how a hearing may be held, but as I said, this committee can promulgate rules and regulations that carry out the provisions of the nuisance chapter. So that's largely something that I would file under housekeeping, that the due process piece of this is most important, and I'm certain that we'll take some time to make sure that any rules of the hearing will be as fair as possible. So on to remedies. This is after a notice and opportunity to be heard and the actual hearing. This committee is empowered to order certain things take place. So the discontinuance of the activity that's causing a nuisance. This committee can order the closing of the building. So essentially that means after a period of time, a short period of time, the Auburn Police Department would clear the building and secure the building, and the building would be vacant for a period of time. This committee has the ability to suspend or revoke a C of O for 6 months or a year, to suspend or revoke any occupational license or permit issued by the city. So this particular item is more applicable, I think, to a business, but there are certainly in other larger cities businesses which constitute a nuisance. So perhaps that will come in front of this committee, and to suspend eligibility to secure grants or loans from the city of Auburn. Each of these remedies can be applied individually or separately or together. So enforcement. Once the committee has a remedy which it thinks is appropriate, the orders are posted on the building and they're mailed to the owner of record 5 days after mail, after posting and mailing. The police department is authorized to act upon the orders. Areas for discussion: how to best foster and streamline input from the community. When does a problem property become actionable? I don't know if we're ever going to come up with a number of violations or a period of time, but it's certainly something I think worth thinking about. And should quality of life issues not contemplated in the nuisance chapter be incorporated? So these are code enforcement. There are a lot of municipalities throughout New York State that have nuisance chapters of their own that do incorporate code enforcement issues. So this, finally, I'll just finish with getting in a plug for my favorite piece of software here. This is the building blocks package that we, through the planning department and city manager's office, have been working to really implement. This is a good example, along with the departments that make up this committee, working together with the folks in City Hall. That's going to be necessary, of course, I think, to the success of this committee, but this ability to analyze data and process data in a meaningful and expedient way is going to be very helpful. So we'll just go to police calls for service. Let's say within the last 12 months, let's say 20. That seems like a lot. So let's see what we have here for 20. I think I might have heard a comment from the chief over there that 20 may not be a lot, and you can see there's a lot of properties here that have had over 20 calls for service in the last year. So, well, if that's not a lot, then let's say 30, 330. And there are still a significant amount of properties that would fit that. So let's see.
Can you remove commercial from that and just?
Yes, thank you, Chief. That's definitely part of it. Let's see. So service. Let's say in the last 6 months, building attributes, property attributes, use, residential. So this, there it is. There's the big one that we've litigated on. So we know that 30 in the last 12 years is a lot, or 12 months is a lot. Let's see, 20 in the last 12 months. And these are non-commercial, these are residences that have had a significant amount of police activity in the last 12 months. So I think we can use this as a tool to guide this particular committee in where to go next, I guess. So with that, I'm finished up here, unless there's any questions.
I think one of the things to keep in mind is what you're looking at on the screen is calls for service, and not to say that those calls are not legitimate calls for service or significant issues, but there is also a possibility that it'll be up to the committee to look at that and get information from the staff. In cases of ongoing neighbor disputes, we will look through to find out what the nature of those calls were and if there was any action taken, right? So if I was having an issue with my neighbor, I could attempt to bolster my argument by just repeatedly calling the police department for issues maybe that don't rise to that level. While we encourage folks to call the police department when they're having a legitimate issue, we also need to be careful about abuse of the system. That typically, I would think, happens on a day-to-day basis with the interaction between a responding police officer and the caller when that happens. But something that we definitely need to look at, and I just want to make sure that that's clear for everybody that this committee, again, is not really here to deal with personality discrepancies between two individuals as much as it is real, legitimate problems.
Absolutely.
Between parties.
The remedy that this committee is, the remedies that this committee is empowered to impose are significant enough that the committee will need to take a deep dive into these calls for service. Absolutely.
But I think we certainly are aware, especially our representatives from the police department and even our folks from our code enforcement office, the types of problems that could potentially be addressed through this committee have increased, especially over the last 12 to 18 months. I don't know exactly how COVID plays into that, but certainly it plays a role. And there certainly has been a lot of outreach to our various staff to try to address some of these issues. I've got a question related to, you mentioned notice a few slides back and who would be noticed when there was action being taken. And amongst that list, right, you've got the owner, lessor, lessee, and mortgagee, right? In the end, the only responsible party ends up being the property owner.
Yes.
Though, right?
Sure.
So the property owner ends up bearing responsibility for the actions on that property regardless of whether they are the cause of it.
Absolutely.
They actually, is it feasible or possible that a property owner could bring a complaint against their own property based on the issues they're having with a tenant?
In my opinion, that would be possible, and that property owner would need to, in doing so, would avail themselves to the remedies at this committee's disposal, which are significant. And if that person were my client in a private setting, I would not advise them to do that.
I would see that could possibly, as we're talking now with the moratorium on evictions still in play, we've seen landlords, property owners become pretty creative on how to work around that eviction process. So I could see this trying to play into that remedy.
Sure. And the good thing about this committee is that, and doing this administratively, is that there are no particular laws of procedure passed by the New York State Legislature that require that everyone that files out a particular piece of paperwork, in such as an eviction proceeding, gets to be heard. You know, we can filter that, largely. And my strong suspicion is that this committee would not be interested in hearing, in carrying the water of, to put it plainly, of a landlord that is not able to evict his tenants, his or her tenants. That's not the. I can see people thinking that landlords thinking that would be something they could try, but that's just really not the appropriate forum for that here.
So, as a matter of procedure, what we will end up doing is we'll take complaints. Those complaints could come either from staff, potentially from code enforcement, potentially from the police department when they are aware, notice a marked increase in the number of responses or complaints related to a property, or it could come from a neighbor, correct?
Yes.
Is there any restriction on where that complaint could come from? So I live on the west end, right? Do I have to be contiguous to a property or in a general vicinity, proximity to a property in order to do that?
My initial thought on that is that certainly there's no prohibition in the nuisance chapter regarding that. However, the two prima facie evidence of a nuisance, the violation and the adverse impact, if we're talking, if residents or citizen complaints are going to be what proves an adverse impact or what proves a violation, if you're halfway across town and you notice that there's loitering, that is less of a that's weaker proof than a neighbor that notices that, and that would be my assertion.
You have a hard time attributing the impact on you personally.
Yes.
We've got about 20 minutes. I just want to make sure that Mr. Garland's got time to get through the rest of his presentation.
I am done.
You are done?
So.
Okay. So we do have a little bit of time.
Did we want to go over the complaint form? I'm sorry.
Yeah, so we do have a complaint form, so I don't know how long that'll take for you to go through that. Are you able to bring that up or no?
Let's see. Thank you, Manager. I should have touched on this in my presentation. So this is, I believe I referenced the complaint form. This is the complaint form that we are pushing out. I believe it is on our. Thanks. I believe it's on our website now, and it was drafted with the. Thank you, Chief. With the idea in mind that we don't want to discourage public input, certainly, but that a nuisance is a term of art within the city municipal code, meaning it's defined in a particular way and has elements, as hopefully was clear from my presentation, that there are legal thresholds that need to be met. So the form was drafted, as I said, to help people who are experiencing a problem property in their neighborhood hone down on exactly what those activities are that they're observing, and help us internally determine whether or not that could factor in as a violation, as we discussed, or adverse impact, which would help us, help the city determine whether or not there was a nuisance taking place in the neighborhood. So, and this section here are some of the things that can go to prove a nuisance, or would present prima facie evidence of a nuisance under the violation theory or the adverse impact theory. There is also a section here, I believe, right up top here. Do you wish to remain anonymous at this time? However, we've only had one of these cases so far, in which we were currently litigating. Certainly, it's understandable that if people wish to remain anonymous, we would honor that wish. But in the case that we're litigating now, neighbors were very brave, frankly, in my opinion, and decided to put their name on paper and swear affidavits. So we will be looking for that form of proof in our administrative process as well. So this section here of the form lets the individual that's filling out the form list any other people that they think might have knowledge of similar incidents. So we are looking to put together as strong of a case as we can, and my hope is that this form will help us do that.
Can I add to that in regards to, like Corp Counsel, Mr. Garland stated, you do have that right to remain anonymous, but this is a partnership that we see. We need the public's help. We need you that lives in the neighborhood feeling the adverse effects of the nuisance personally, because we don't at 46 North Street all the time. Yeah, we do respond to your calls for service, but it really is impactful when we can take an affidavit from you, the neighbor, and how it's changing or affecting your life. So if we can get your cooperation, the adage, help us help you, that really comes into play. And I understand, we understand the fear of putting your name, your pen to paper, because you feel that there might be retribution if somebody knows that you made a complaint against them, especially a problem neighbor. We absolutely understand that, but if you do find it, in your efforts to assist us with giving that affidavit, it's really going to be that much more impactful going forward as we hear these cases. Thank you.
So, Mr. Garland, as we move throughout this, and I think probably by the next time we meet, we'll have some actual addresses to discuss. I can't believe, looking out here at the audience, that we won't have at least a few items to discuss the next time around. But as a matter of how we tackle those things, once we receive in complaint forms, various staff will investigate the number and types of calls for service, the conditions of the property, and do some of that background work. Prior to the actual meeting, we may have some indication whether or not the complaint rises to a level where the committee will act on it, take some sort of punitive action. But along the way, it seems like it would be reasonable if we receive a complaint that will start a communication with the property owner. It doesn't seem that it's necessarily required, but that would be just a course of action for us.
Again, Mr. Manager, this committee is empowered to make rules to fully enforce the nuisance chapter. So in my opinion, that means that an intermediate step could be crafted where certain measures are taken to let the owner know that, property owner know that they are on the city's radar, and perhaps they had no idea of the particular situation, and they wish to not allow a nuisance to take place. So I think that's absolutely within this board's power.
And as an example, and something that the manager and I were just discussing at yesterday's department head meeting, we have a certain commercial establishment that has come to our attention. I did run calls for service over a 2-year period, and it is an obscene amount. Would you imagine that letter coming from your office? And I'm just trying to come up with a format, and I think that's a proper way is to alert them, as you said, maybe the corporation is not aware, and they would be a partner in remedying the situation to that establishment. Do you see a form letter of notice coming from your office?
Well, I defer to the Corporation Counsel, but I will say that in instances like the city's false alarm code, that our office does send letters to corporations saying that you're, there's a section in the municipal code that requires people that have alarms, burglar alarms, to stay on top of them. And sometimes, I learned this actually on the job, that sometimes businesses let alarms go, basically, and don't pay attention to how many false alarms they're having, and that the city expends resources in responding to those false alarms. And so there's a section in the municipal code which sets a fine after a certain number of false alarms. So the Corporation Counsel's office, after receiving correspondence from the police department, will notify that oftentimes corporate entity that they're whoever they have boots on the ground in Auburn, New York, is not paying attention to this particular piece of the municipal code, and perhaps that's how we would tackle.
I'm just asking for a matter of procedure. I surely don't want to put more work on your office, but if we could come up with a form letter, I should say, when these types of things come to our attention, that we can start that process with the notification. And I think this one that we spoke about may be a good first step as well on that commercial entity. So we'll discuss that further. Thank you.
Anything else, chiefs?
You're awful quiet.
Taking it all in. You got a lot to say.
Yeah.
Okay. You can send that directly to the city manager's office if you'd like, and we'll process them from there. We have approximately 15 minutes before we need to vacate council chambers to allow the next scheduled meeting to happen here. If some of you have got some questions or clarifications, we can allow that now. I just ask you to keep your comments or questions brief. We'll do the best we can to answer them. We'll adjourn this meeting just before 10 o'clock. And as I mentioned before, if some of you have questions for the chiefs or myself, we'll attempt to at least hear what you have to say. I'm not going to tell you we're going to give you an official response in the hallway, but I know many of you have concerns and have taken the time to come here today and listen to this, so we'll try to accommodate that. So, ma'am, I think you had your hand up before. If you don't mind, could you come up to the podium? Do you mind doing that so that everybody can hear you? Can you speak really loud then? Because this is being live streamed and recorded, so we want to make sure that that's audible.
I'm misguided, but this all seems to revolve around unresponsive landlords/owners. I mean, I own property. I'm aware of how my property is kept. It's, like I say, maybe I'm coming from, but I think it's just unresponsive homeowners that are vacant, don't live in the area, and
Unfortunately.
go by the property every day and look at how it's affecting the neighborhoods.
Unfortunately, that's not what we necessarily see on a day-to-day basis. I can tell you, years ago when we started to venture into the vacant property registry, We really thought that a lot of the ownership was going to be absentee owners that lived out of state, and I was unfortunately surprised how many of the property was locally owned and just not maintained. So we have a pretty even mix of absentee landlords and landlords that are very well known to us and we have nearly daily interactions with.
I'm sure. Thank you.
Yep. We've got a couple minutes if there's any more things.
Don't be nervous.
My problem is with my neighbors, threatening me, calling me names in my backyard, setting off fireworks next to my property line, throwing food over the fence for my dog. It's a purebred dog. I don't feed her that type of food, threatening to steal my dog. It's just a nightmare. I can't even go to my backyard. I pray for rain every day so I don't have to deal with them. We put up a new privacy fence from our shed to the corner so if they couldn't see me or my dog in the backyard, it would improve the situation, but it didn't because it's been 3 weeks. He waters my fence now every day. He, like I said, he does fireworks that just sparks up like a foot from the new fence, and my shed's right there too. And it started a year ago when he was doing fireworks that were landing on our brand new carport. The fireworks themselves were landing on them. And we've called the police a number of times. He goes by my house now. He did last night when I was coming home from work, and he just stares at me. I've gone to try to get a restraining order against him because he threatened to punch in my face. And like I said, we've been there for 25 years. We've never had problems with neighbors because it's horrible. He says he's going to jump me if I walk my dog. I just don't know what to do. I can't get a restraining order. Nothing. And he's a known criminal. There was an article in the paper from him in 2012 saying the interview was about career criminal. We've contacted the landlords. Well, the landlord, no offense to landlords, they said that they deny it. I sent them videos. I sent them. I get nothing.
Okay. Again, we don't have the time or ability at this point in time to get into details of specific cases. A lot of things that you mentioned, as I seem very aware, are issues that are law enforcement issues, that are calls that when those things are happening, it should probably be a call from you to 911.
Right.
And it sounds like you have some experience there, but I'm sure the police chief can.
Because I'm the one that calls, he threatens me.
I understand that. I would ask that the police chief just have somebody communicate with you. I don't know if that's already happened, but we do have some points of contact in the police department to help you work through those issues. Not saying that this is not a potential vehicle to get you where you need to be. That is one option, working with the police department. And I will say, as I'm looking out into the audience at our corporation council, one of the remedies that is out there that is very, very seldom utilized is a direct action between you and your neighbor, a civil action between you and a neighbor or a neighboring property owner in the courts as well. Just throwing it out there so that you're aware.
Association to get an attorney. No one, I can't come up with an attorney.
Okay.
I talked to Mike, I talked to Jared, I've talked to people. And trust me, I'm gonna get, he's gonna say stuff because I was here today, because he'll know. The neighbor.
Okay. All right. Again, I know the police chief's writing down notes here. We'll have some further communication with you. Okay?
I just want to be safe in my house.
Right. Okay. I think at this point, so that the next meeting can get in here, now would probably be a good time to adjourn this meeting. I want to remind everybody that the next meeting will be Wednesday, July 21st at 9 a.m. All right, we'll continue this on a fairly regular basis on the third Wednesday of each month at 9 a.m. Okay. Chief Fritz, you good?
I'm all set, thank you.
Probably do a official motion to adjourn. If one of the chiefs would be willing to do that.
I'll second that.
Oh, wow, okay.
All in
Takes
favor?
care of that in short order. Okay. Motion to adjourn.
Aye.
Aye.
All right. Meeting is adjourned. Thank you. Thank you, Mr. Garland.
Thank you.